Good afternoon, everyone. I'm Paul Carisse. I'm the director of the School of Civic and Economic Thought and Leadership at Arizona State University. And I'm delighted that we have the second of our visiting scholar talks this semester. In what seems like, I don't know, 5 or 6 months ago at the beginning of the semester, we had a marvelous presentation by our other visiting scholar in the school this semester, Professor Catherine Zuckert, and today we hear from Professor Michael Zuckert. We are delighted that the Zuckerts have joined us now in their second spring semester with the school as visiting scholars, and we hope that that relationship will continue. To introduce Professor Zuckert, who for some of us needs no introduction, but he is due at least a brief introduction. He served at Notre Dame as the Nancy Dreux Professor of Political Science and is just recently emeritus from Notre Dame. For many decades, his scholarship and teaching have worked in the fields of both political theory and constitutional studies. Among his published works are the books Natural Rights and the New Republicanism, The Natural Rights Republic, and Launching Liberalism. He's also written and edited many other works on American constitutionalism, the political thought of the American founding, Abraham Lincoln, many other topics. I will mention that he also has co-authored and I believe co-edited books with Catherine Zuckert about the political philosophy of Leo Strauss. Today, he's going to speak to us about a project he's working on, the constitutional thought of James Madison, which we very much hope will this will be a chapter in a forthcoming book about the thought of James Madison. So we thank you, everyone, for joining us. I'm asked to tell you that we will have time for questions after Professor Zuckert's presentation. So if you would use the Q&A function in Zoom, those questions will be funneled to me, and I will look forward to posing those to Professor Zuckert. And so with that, Professor Zuckert, the floor is yours. Thank you very much for being with us today.
Paul, thank you very much for that introduction. I look forward to hearing the questions from the audience out there. My topic, as probably you've heard, is the sound of the third hand clapping. That very Zen-like topic. I'll try to explain what it means as I go along. Turns out that a topic actually rather closely related to mine recently vaulted into the news of the day when President Trump claimed total power to control the response of the states to the coronavirus pandemic. Indeed, it turns out that one of the abiding conflicts of American constitutional history does concern the extent and scope of powers vested in the government of the United States vis-a-vis the states. As you may know, the Constitution in its Article 1, Section 8 lists a fairly large number of powers granted to Congress, among which are things like the power to regulate commerce with foreign nations or commerce among the states, things like that. In addition to these very specific and explicit grants of power, there is a clause, however, that has stood at the center of the abiding conflict over the powers of the US government, the so-called Necessary and Proper Clause. It reads like this: Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. This provision received its authoritative Supreme Court interpretation in an 1819 case called McCulloch versus Maryland. Here we are 201 years later, and McCulloch versus Maryland is still one of the most widely read and discussed cases in all of American constitutional history. One of the interesting aspects of this case, of the attention paid to it over the years, is the degree to which the relevant literature about it was written well before the case occurred. You may wonder, how could that have happened? I'll try to explain. The most widely read commentary on this case over the years has probably been Alexander Hamilton's opinion on the constitutionality of the Bank of the United States, which was written about 25 years prior to John Marshall writing the Supreme Court opinion in that McCulloch case that I mentioned. The second most read opinion on the case is probably Thomas Jefferson's, prepared as was Hamilton's at the behest of President George Washington, as Washington pondered whether he would sign the recently passed congressional bill establishing the Bank of the United States. Jefferson and Hamilton are the two hands clapping. There was a third hand, or set of hands, that is surprisingly, in my opinion, not among the most widely read and discussed early commentaries on the constitutional themes raised by the effort to charter a Bank of the United States. This third hand is the opinion on the bank's constitutionality delivered by James Madison, at that time a representative from Virginia in the US Congress. The relative obscurity, I should say, of Madison's opinion is surprising for a number of reasons. First, because of his stature, both in general and as a particular authority on the Constitution. Second, because he was one of the major, he was really the first of the major authors to put forward a carefully worked out interpretation of the necessary and proper clause, which was the part of the Constitution most at stake in that debate over the bank. And third, he opposed this bill, the Hamiltonian bill, in Congress well before it was adopted and came to President Washington for his approval. Finally, and most importantly, and this is the main brunt of my argument today, most importantly, his opinion not only differed from that of the other participants in the debate, but it was arguably, I'm going to maintain, the most constitutionally correct of the batch of opinions then and since. Now, one reason why Madison's position on the bank has been more or less ignored derives, I suspect, from a tendency among scholars to assimilate his position to that of Thomas Jefferson. This practice, in turn, is related to the tendency among scholars to see Madison as having been, in effect, captured by his friend's political ideology in the years after the drafting of the Constitution. Madison did share with Hamilton certain fears of where Hamilton's expansive interpretation of the Constitution would take the nation. So in his congressional speech against the bank bill, Madison rejected any interpretation that, in his words, would give Congress an unlimited power and would thus render nugatory the enumeration of particular powers. In somewhat more poetic language, Jefferson later made a similar point. As he put it, to take a single step beyond the boundaries thus specially drawn around the powers of Congress by the 10th Amendment is to take possession, he said, of a boundless field of power no longer susceptible of any definition. Both men, Jefferson and Madison, wished to preserve limitations on the powers of Congress and to retain the meaningfulness of the enumeration of powers in Article 1. Nonetheless, their arguments to reach the conclusion that this bank bill went beyond the Constitution and stepped into that boundless field of power of which Jefferson spoke, their arguments were actually quite different. Jefferson took his stand mainly on the meaning of the term necessary in the necessary and proper clause. The Constitution, Jefferson said, allows only the means which are necessary, not those merely convenient for effecting the enumerated powers. If such a latitude of construction be allowed to this phrase as to give any non-enumerated power, it will go to everyone, for there is not one which ingenuity may not torture into a convenience in some instance or other to some one of so long a list of powers. It would swallow up all the delegated powers and reduce the whole to one power. Therefore, it was that the Constitution restrained Congress to the necessary means, that is to say, to those means without which the grant of power would be nugatory. That's Jefferson's take on the necessary and proper clause. This language of means without which the grant of power would be nugatory became central to the debate on the necessary and proper clause when Hamilton picked it up as the chief target of his counter-argument on that clause. Later on, Chief Justice Marshall followed Hamilton in rejecting Jefferson's reading of that clause. But Madison's case against the bank nowhere depended on Jefferson's claim that necessary means without which, or absolutely necessary, as it was rephrased in various later restatements. Now, Jefferson gave an essentially restrictive reading of this necessary and proper clause. Congress, he implied in his opinion, has the right to use means to effectuate the granted power, but only those means without which the powers granted would be nugatory. But the placement of the necessary and proper clause strongly supports a less restrictive reading. It is the last of a very long list of powers granted to the government in Article 1, Section 8, and it seems intended to continue the process of adding powers that is the character of Article 1, Section 8. Moreover, in the next article, Article 1, Section 9, the emphasis clearly shifts by enumerating a set of limitations on congressional powers. For example, Congress's exercise of its enumerated powers is limited by the prohibition that no bill of attainder or ex post facto law shall be passed. Now, Jefferson's version of the necessary and proper clause would fit better into Article 1, Section 9, which is visible if we restate it as follows. No laws, Jefferson's opinion amounts to, shall be made to effectuate the aforementioned powers unless the absence of which would render nugatory an enumerated power. Madison, on the other hand, reads the necessary and proper clause as a grant or a recognition of the presence of additional or implied powers. The two friends, Madison and Jefferson, shared an aversion to the Hamiltonian, Marshallian rendition of implied powers, but they did not agree with each other on the correct reading of the clause. Of course, the word necessary, being contained in the necessary and proper clause itself, appeared frequently in Madison's speech on the bank bill, but it was never joined by him with the word absolutely or similar terms as that. Although the unless nugatory test is not the central part of Madison's exposition, it is a major part of Hamilton's. In Hamilton's opinion on the bank, he took strong issue with Jefferson's construal of the word necessary as implying the unless nugatory rule. According to Hamilton, as he puts it, neither the grammatical or popular usage of the term necessary requires the construction that Jefferson gave to it. Necessary, Hamilton pointed out, often means no more than needful, requisite, incidental, useful, or conducive to, much looser reading than Jefferson's, as you can see. Now, Chief Justice Marshall, in his heavily Hamilton-influenced opinion in the McCulloch case, made a very similar linguistic argument to that of his mentor, Hamilton. He asked whether the Jeffersonian equation of necessary with the unless nugatory principle holds up. Here's what he said. Does the word necessary always import an absolute physical necessity so strong that one thing to which another may be termed necessary cannot exist without the other? The Chief Justice thought not. As he put it, according to its common use in the common affairs of the world in improved authors, we find it frequently imports no more than that one thing is convenient or useful or essential to another. So the sound of two hands clapping is thus the cacophony produced by the different assertions about the meaning of necessary. Each of the parties to the debates developed a test to demarcate the line between what is or what should be allowed under the clause and what not. For Jefferson, that test was this unless nugatory standard. No matter how limiting the warrant for implied powers under Jefferson's test, there still was room for some implied powers under it. Hamilton, however, insisted that no matter how much looser his reading of the necessary and proper clause was, it still did not justify the unlimited implied powers as both Hamilton and Madison averred. As a counter to the accusations that he faced, Hamilton laid down what has become a famous test for the legitimate derivation of implied powers. Here's what he said. The only question must be whether the mean to be employed has a natural relation to any of the acknowledged objects or lawful ends of the government. Now, this test not only delineates the scope of the necessary and proper clause, but also its limitations. He illustrates the latter by distinguishing the legitimacy of Congress exercising an implied power to charter or incorporate the proposed Bank of the United States from a corporation, as he put it, superintending the police of the city of Philadelphia, because they, Congress, have no authority to regulate the police of that city. Now, Chief Justice Marshall, in his opinion in McCulloch, laid down a rule very similar to Hamilton's. Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional. Now, responding in advance, so to speak, remember Madison developed his position before any of the others did. Madison took quite a different road from the debate over the meaning of the word necessary. As the congressional reporter restated Madison's chief point in his report on the debate that occurred in Congress on the bank, the reporter said that Madison here adverted to a distinction which he said had not been sufficiently kept in view between a power necessary and proper for the government or union and a power necessary and proper for executing the enumerated powers. I'm going to repeat that because it turns out to be a very important statement for the general argument I'm going to make. The distinction that Madison adverted to was a distinction between a power necessary and proper for the government or union and a power necessary and proper for executing the enumerated powers. I'll try to explain what that's all about as I proceed. With this observation, though, Madison introduced a very different consideration into the debate. There are, Madison pointed out, two conceptually different kinds of necessary and proper powers. There is first power necessary and proper for the government of the union, what we would call the federal government. We might understand what Madison is getting at with this notion of necessary and proper power if we look at the issue from the point of view of constitution makers, which Madison had very recently been. The task of the constitution makers is to generate a constitutional scheme, including the empowering of the government. If they aim, as the American founders did, at a government of enumerated and express powers, they must first figure out what powers are necessary for the successful operation of the government. They must begin by specifying for themselves just what government must do, what it must accomplish. These specifications were often called by Madison, Hamilton, and other of the founders the objects of the government. When Madison introduced the series of papers in the Federalist, papers number 41 through 46, a series which detailed the powers allocated to the general government, he affirmed that the detailed review of the powers conferred may be conveniently done if they are reduced into different classes as they relate to the following different objects, right? Powers and objects, two things he's talking about here. The powers may be clustered into classes of objects because there's a relation between the powers and the objects. He identified these clusters of powers with 6 different objects. He thought the chief objects of the government, of the federal government. A few of them will give a good idea of what objects are and how they relate to the powers. So the first object that Madison listed is security against foreign dangers, one of the clear goals of the founding generation when they made the Constitution, to provide security against foreign dangers. The third is restraint of the states from certain injurious acts. Again, another important goal that the founders had in drawing up the Constitution. In this and the succeeding papers in the Federalist, Madison proceeded to list the enumerated powers that relate to these objects. And explaining the powers related to security against foreign dangers, he identified such security as one of the primitive objects of civil society. It is, he said, an avowed and essential object of the American Union. These powers, the powers requisite for attaining it, he went on, must be efficiently confided to the federal councils. So among those powers necessary to both civil society in general and the American Union are, as he put it, the powers of declaring war, and also the powers of raising armies and equipping fleets. And we can easily see the connection between those powers and the object of providing security against foreign powers. Now, Madison saw the relation between objects and powers as a relation of ends to means. That's pretty clear. The powers are necessary means to achieve the objects. The Constitution makers, in their task of empowering the government, begin actually by identifying the objects in view, and then they infer the powers that are necessary to achieve those objects. These inferred powers are then put into the Constitution. They are the sort of necessary and proper powers adverted to in Madison's speech against the constitutionality of the bank, the first kind of power he referred to. The second kind of necessary and proper power is one necessary and proper for executing the enumerated powers. He's making a distinction between powers necessary and proper relating to the objects of government and powers necessary and proper relating to executing the enumerated powers. What Madison believes has been lost sight of is that these are two different kinds of powers that are both necessary and proper, but in different ways. The first set includes all those powers that can be inferred from the objects of government. Constitution makers take this set of implied powers and transform them into enumerated powers by expressly putting them into the Constitution. As Madison makes clear in Federalist Paper number 41, this process can also be reversed. A constitutional interpreter can begin with an already existing constitutional text into which the Constitution makers have put the powers that they inferred from the object that they've identified. So Madison inferred the enumerated powers into classes or sets of powers that helped identify the objects sought by the Constitution makers when they decided what powers expressly to include in their Constitution. So it's a process that can go both ways. For the Constitution makers, down from the objects to the powers. For the constitutional interpreter, up from the enumerated powers to the objects. Now, the other kind of implied power works similarly, but with an especially significant difference. The second kind of implied powers are derived from the first sort, but only when this first set has been expressly placed in the Constitution in the form of enumerated powers. These second sorts of implied powers are those that are inferred to be powers necessary and proper for executing the enumerated powers. Like the first kind of necessary and proper powers, these are derived as means for effectuating certain ends. In this case, the effectuation of the enumerated powers. The enumerated powers are those express means to the achievement of the ends known as objects. The enumerated powers then switch from being means to being ends. They in turn imply means to their achievement, which are the necessary and proper powers of Article 1, Section 8, as identified in the necessary and proper clause. These are then the ultimate means in a chain running from objects, which are the ultimate ends, through enumerated powers, which are intermediate entities, both means and ends, and the necessary and proper powers per se, that is to say, implied means to the enumerated powers. As Madison rightly said, the distinction between the two sorts of necessary and proper power is absolutely essential for correctly interpreting and applying Article 1, Section 8, Necessary and Proper Clause. The wording of this clause, when read in light of his explanation of the complex conceptual structure in play in the set of objects, enumerated powers, and of implied powers, becomes very clear in meaning when we approach it in this way. This clause, we should now notice, provides, this is the necessary and proper clause, Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. The constitutionally implied powers are only those effectuating the enumerated powers, not the objects related to those enumerated powers. Article 1, Section 8 allows the derivation of further powers as means, but only further powers that are means to the enumerated powers, not to the objects of government of the Union as such. Although we can infer from the enumerated powers a notion of these objects of government, inferring further powers from the objects as inferred from the enumerated powers is not authorized. Working from the examples Madison provided, we can see rather easily what the Constitution authorizes and what it does not. Among the enumerated powers are many powers related as means to one of the major objects of government, such as security against foreign dangers. Among the powers granted to the government to achieve that object is the enumerated power to raise and supply armies. There are, however, numerous ways in which an army can be raised. These are the powers needed to carry into execution the enumerated power to raise an army. So in order to raise an army, Congress might, for example, establish army recruiting stations throughout the United States. Congress would have the implied power to do so from the necessary and proper clause as it is written. But there are other means that Congress could deploy as implied powers to that same end. It could, for example, set up a bounty system to procure soldiers. The necessary and proper clause, as read correctly by Madison, also sets limits to the implied powers. Madison tells us that no power not enumerated can be inferred from the general nature of government, but only from the enumerated powers. I'll try to explain what he means by that. Constitution makers have the authority to conclude what powers are necessary and proper to achieve the objects of government and to include these powers as the enumerated powers in their Constitution. Subordinate legislators like Congress then have the power to derive further implied powers from the enumerated powers, but not from the objects directly. Madison provided a stunning example of what cannot be an implied power. Here's Madison. Had the power of making treaties, for example, been omitted, however necessary it might have been, the defect could only have been lamented or supplied by an amendment of the Constitution. Implied powers can be derived from the enumerated powers, but not from the objects or ends of the vested powers, even though a treaty power could be a useful, valuable, even necessary power related to safety against foreign enemies. Nonetheless, it cannot be derived by under the necessary and proper clause if it were not actually included in the Constitution. The difference between Madison's and Hamilton's construals of the necessary and proper clause is evident in the language that they use to explain the terms of the necessary and proper clause. According to Hamilton, the only question must be whether the mean to be employed has a natural relation to any of the acknowledged objects or lawful ends of the government. That is to say, according to Hamilton, legitimate implied powers are all those that can be derived from the objects or lawful ends of the government. Madison leads us to see that this is precisely not what the Constitution authorizes. Perhaps the Constitution would be a more rational document if it were as Hamilton construed it to be. But Madison's point is that constitutional interpreters and subordinate legislators are bound to the Constitution that we have, rather than the Constitution as some, like Hamilton, would prefer it to be. Madison weighs the actual enumeration of powers so heavily as he does because the fact of enumeration identifies a or even the leading feature of the Constitution as he understands it, that its powers are enumerated. And if later interpreters had a right to amend, that is, add powers via construction of new powers at the level of these enumerated powers, the overall character of the Constitution as one of enumerated powers would be lost. In distinguishing between the various sorts of necessary and proper powers Madison points to a different approach to the necessary and proper clause from that taken by Jefferson, Hamilton, and Marshall. All three of these interpreters claimed that the issue at stake is how necessary the implied powers are. Absolutely necessary, conducive to, or something in between. Madison conceptualized the matter entirely differently, however. It is not a matter of how necessary, but necessary for what. An implied power may be one necessary for the government or union, that is the question the Constitution maker is driven to ask, or one necessary for executing the enumerated powers, that is the question constitutional interpreters or legislators are driven to ask. So as we've seen, Madison was opposed to the Hamilton-Marshall technique, in part because of its implications for the enumerated powers, but even more decisively because it was based on a clear misinterpretation of the text of the necessary and proper clause. Had the Constitution makers meant to create a Constitution with the meaning Hamilton and Marshall attributed to it, they would have written their Constitution differently. First of all, the Constitution makers could have drafted a necessary and proper clause in language different from what appeared in Article 1, Section 8. They could have written this: Congress shall have the power to make all laws which shall be necessary and proper for achieving the objects and ends of this Constitution, which is basically what Hamilton's and Marshall's theory amounts to. More radically, but in practice the same, the Constitution makers could have foregone the enumerated powers altogether and merely listed the objects they had in mind and affirmed Congress's power to achieve them. These alternate ways of providing for implied powers would validate the Hamilton-Marshall approach of moving from expressly granted powers to inferred objects of those powers and back down to implied powers that are further means to the objects found to be implied by the expressly enumerated powers. Madison's chief objection to this procedure derived from his observation that the language of the Constitution is just not compatible with that approach. The language of the necessary and proper clause does not fit their procedure. The clause very explicitly validates implied powers to effectuate expressly granted powers. This rules out the direct appeal by the constitutional interpreters to the objects and ends. The Constitution makers begin with a notion of objects and ends, but do not directly grant all powers that might contribute to accomplishing those objects and ends. The absence of some possible powers from the explicit grant of powers might have been quite intentional, and the Hamilton-Marshall approach might lead to serious distortions of what the Constitution makers sought to accomplish. Madison used the hypothetical absence of an express power to make treaties. This may be a mere, although it would be a very important oversight, but then it may not be. Granting, he said, that the Constitution makers accepted security against foreign dangers as a valid intended object of the Constitution, and that they provided many of the express powers that they did in order to achieve that object, it nonetheless does not follow that they would admit the validity of any or all unexpressed powers that arguably serve the end of security against foreign powers. We could take torture as an example of a power that could be taken to serve the purpose of security. But this could be one which the Constitution makers could have meant to intentionally exclude from the powers granted for that purpose, but it is not clear that the Hamilton-Marshall approach would in fact rule it out. So apart from the specific language of the necessary and proper clause, Madison found the Hamilton-Marshall approach not to accord with the overall character of the Constitution. Marshall famously said, "We must remember that this is a Constitution we are interpreting," to which Madison would add that it is a Constitution of enumerated powers. If later constitutional actors were free to appeal directly to the object and ends that presumably guided the Constitution makers in their making, then it made no sense for the Constitution makers to have explicitly listed the powers of the government. So, in absolute final conclusion, I think there are at least two major clusters of questions that remain from this conversation. First, if, as Madison has it, we must either lament or amend in the absence of powers necessary for accomplishing acknowledged ends or objects of the government, for example, the treaty power, Is this the sort of constitution we should feel stuck with? Ought we to accept a less literal reading of Article 1, Section 8 as the more effective and wise constitution? Second, acknowledging as we must that the Madisonian Constitution would have brought us a smaller federal government, would this have been the more desirable path for American constitutional history? With those questions, I close and thank you for your attention.
Thank you. Thank you so much, Michael. We have some excellent questions in the queue.
Okay.
I want to maintain the spirit of our carefully constructed constitution of distributed and balanced powers, and not claim some kind of arbitrary total executive power to dominate all the questioning of you. So I do promise to get to those excellent questions in the queue, but I will take the privilege as chair, so to speak, to ask a clarifying question in a way to amplify, extend your argument. Could you speak for a moment to the application by James Madison in 1791 of these principles that you have spelled out? He therefore made the next step that there was not a reasonable way to interpret the incorporation of a bank as necessary and proper to any of the preceding powers enumerated in Article 1, Section 8. Could you spell out just some of the specific steps? Because it seems to me you could say, well, for raising armies or for coining money or for several other clauses in Article 1, Section 8, incorporating a bank could be seen as a reasonably necessary, not the extreme restrictive Jefferson interpretation, but it could be seen, but clearly he didn't. So could you just spell that out?
Well, I'd like to make a distinction between the actual arguments that Madison made in rejecting the idea that the bank would be a necessary and proper means to achieving the enumerated powers, to effectuating the enumerated powers. I'd like to make a distinction between that set of reasoning and his broader reasoning about the necessary and proper clause itself. It seems to me, and I think he admits this, those kind of questions. Is this piece of legislation in fact a necessary and proper means towards effectuating some or any of the enumerated powers? That's a question which is oftentimes debatable as to where one comes out on the answer to it. And in my opinion, I think there's some, I mean, I'm not entirely persuaded by his rejection of the idea that the bank could not be a reasonable, necessary, and proper means towards achieving some of those powers. What I'm more impressed with and think more important for us, we're not adjudicating the bank anymore, but I think more important for us is the broader question of what does he mean, how we'd understand the necessary and proper clause altogether. And I think I've tried to bring out is really a radically different understanding of what's involved in thinking about that clause than the Hamilton-Marshall approach, which is, I should have said at the beginning, accepted as the orthodox view of the necessary and proper clause in constitutional law ever since McCulloch v. Maryland. So I'm going to dodge your question, Paul. Or I have dodged it already. You're muted.
Sorry.
Yeah.
We have a question from a student, Catherine Clark, that does follow on though. So this is just clarification about what your argument was.
Okay.
So, and I think I heard you the same way. You mentioned the examples that Madison gives of other means by which to raise an army other than incorporating a bank. Yeah. For example, Congress passes legislation about recruiting stations. Congress passes legislation about bounty.
Yeah.
And she asks,
or a draft, or
She asks why the latter would not, according to Madison's view, be an appropriate means to fulfill the enumerated power. But I think you're implying, I just wanted to clarify that you were implying in his view, he was preemptively saying, if we did pass such legislation, I interpret that to be reasonably necessary to carry.
Yeah, I think he would take. In other words, for Madison, the brunt of the effort is not really on the degree of necessity. He wants to see a clear nexus between an enumerated power and this legislation that we're talking about. And so he's not going to push hard in the way Jefferson wants to on absolute necessity. He just doesn't, that's not the issue as he sees it. I think what Madison would say is Congress, so long as it's reasonably fulfilling effectuating one or more of the enumerated powers, Congress has a lot of discretion in what legislation it adopts. So I didn't mean, I think maybe I did, I could have expressed that a little better, not to indicate that this was not meant to be an either or.
Okay, a question now from our friend Elon Werman, who's a professor at the O'Connor College of Law at Arizona State University.
Oh, okay.
I'll read the question as he posed it. Professor Zuckert, isn't it the case that you overstate the difference between Madison on the one hand and Hamilton Marshall on the other? Hamilton and Marshall agree with Madison that the necessary and proper clause is a grant only of implied powers, not of great substantive or important powers. And he then provides two quotations, one from Hamilton, one from Marshall and McCulloch. From Hamilton, quote, "An incorporation seems to have been regarded as some great independent substantive thing, as a political end of peculiar magnitude and moment, whereas it is truly to be considered as a quality, capacity, or means to an end." Then Elon gives us Marshall from the majority, the opinion in McCulloch. That quotation. "The power of creating a corporation is not like the power of making war or levying taxes or regulating commerce, a great substantive and independent power, which cannot be implied as incidental to other powers or used as a means of executing them." So again, the question, have you overstated the difference between Madison on the one hand and on the other Hamilton and Marshall, given these quotations from Hamilton and Marshall?
I mean, I don't think I have, because it seems to me clear in the formulations that I quoted, both from Hamilton and Marshall, that they clearly want to say that the implied powers are understood as means to effectuate the objects of the government, the objects and or ends of the government. They use that language sort of interchangeably. And Madison is very clear in saying, no, they're only to effectuate the enumerated powers. And in practice, it may be that Madison would validate some big power even. So it's not the size of the power, I don't think. Again, it's related to the how necessary theme. It's really a question of, in terms of what, there's necessary for what, as I try to express the Madisonian position. Necessary for what? Necessary for effectuating the enumerated powers, and that it's out of bounds to make an argument necessary for effectuating the objects of the government altogether. So I think it becomes hard to say. I think it becomes hard to say. I'm trying to think of a way to describe the magnitude of powers. It's not really the magnitude of powers that's at issue. It's a question of necessary for what, as I said. You're muted, Paul.
I apologize. There are several questions that ask about later Supreme Court interpretations. Let's say even McCulloch, but then later in our constitutional history. So both from Hale Espinoza and from Zachary German, I'll sort of put the two together. Are there particular Supreme Court cases that come to mind that you think would have been most likely decided differently if the court had been relying upon this Madisonian understanding of the necessary and proper clause, even in the case of McCulloch versus Maryland? Or do you think that a Madisonian understanding would have provided a different framework by which to reach the same decision that Congress had, or the Congress and the President together had reasonably interpreted what was necessary and proper to an enumerated power? The slightly different version of this from Hale Espinoza is, are there members of the judiciary rather than an entire court ruling, are there particular members of the judiciary who you would identify as having actually followed a distinctly Madisonian interpretation of the necessary and proper clause?
As to the latter, I can't think of anybody. I mean, I think one of the interesting things, to my mind, is how much Madison's position has been ignored. Some years ago, I noticed this thing that Madison had said in the debate on the bank, and was very struck by it and thought, you know, this really makes a difference in how one understands the necessary and proper clause. And I had a conversation at that time with a fellow named Lance Banning, who is now dead, but was at that time really, I'd say, certainly one of the one or two leading Madison scholars in the country, and mentioned to him that I thought this position was different, certainly from the Hamilton one, but also very different from Jefferson's, and more solid, I thought, than Jefferson's. And Lance, again, somebody who knew Madison extremely well, just didn't see the point of the difference I was trying to raise, and he persisted in thinking that Madison's position was very similar to Jefferson's, which I think just is not, in fact, the case. So if Lance Banning wasn't aware of the difference, that's an indication of how little known this Madisonian position was. So I can't think of any Supreme Court justice. I mean, there may be some. It's been a while since I've been looking at constitutional law. So there may have been some out there, but I just can't think of anybody right now. And as to cases, I'll beg the same thing. I can't think of a good example right offhand. So again, I wasn't thinking at that level. That would be good. I think it'd be a good thing to do. But I originally worked on this paper as part of a conference on McCulloch, and the idea of so broadening the horizon just wasn't part of my agenda at that time. So my apologies, Zach. Good question, but I'm not sure how to answer it.
I'll speak now, and I'll remember to unmute myself. I'm having a feeling that this is how my wife must think our relationship is for 30 years now. That she's speaking, but I've got her on mute. I'm not really hearing what she's saying. Anyway, I'll try to get better at that. I want to ask a footnote to that question. Carson Holloway's book from just a few years ago, I recall, does include Madison's views on these questions, or is memory deceiving me? That he doesn't. It doesn't
talk about Madison, really.
He doesn't. It is the same focus on the debate within the cabinet.
Right.
Right. Okay.
Right.
Right. I want to give Professor Werman a follow-up, because I think we've got enough time to get onto the other categories of questions. So here's a follow-up from him. As he reads Hamilton's and Marshall's opinions, he thinks they are using the word ends to refer to enumerated powers. So he gives a quotation, Hamilton, if the end be clearly comprehended within any of the specified powers. So Elon says that seems to be a reference to the enumerated powers themselves, which would make your contrary interpretation debatable. And then he adds, and then Elon, this is all you get. So that's it. Then he adds, at the end of Hamilton's own opinion, he says, it remains to show the relation of such an institution, the bank, to one or more of the specified powers of the government. And then he shows how incorporating a bank would relate to the enumerated powers of laying collecting taxes, borrowing money, et cetera.
Okay, I was just looking through my notes to find the version of Hamilton's test that I had here. I'll find it, but give me a minute. What I would say is that to the passage that Professor Werman is referring to, I mean, it seems to me that perhaps. It seems to me that there's a difference. What Hamilton is not oblivious to the powers. That is, they play a part in his way of understanding the necessary and proper clause. The enumerated powers do, but not the same role that they play in Madison's in Madison's version, as Madison makes clear, because he's already opposing the Hamiltonian way of reading that clause. And the role that they play, as I understand it, in Hamilton's version is this. The enumerated powers tell us or point towards what the objects of the government are. There's the enumerated powers. Hamilton looks and he sees these are the means to achieve certain things. These are means to achieve certain things. And we can formulate those certain things from the powers that have been granted. So the power to raise an army is a means towards defense, let's just say. Raising an army is a means to defense. And what Hamilton then seems to me to want to do is to refer to that object or end for which those powers have been granted and infer new or further powers that have not been enumerated, which are means to the object and not necessarily means to the enumerated powers. That, I think, is the role that the enumerated powers play in Hamilton's thinking, and it's not a minimal role. I mean, it's an important role, but nonetheless, it's a role that still liberates him to look above to look beyond the enumerated powers in inferring implied powers in the Constitution. Hamilton, this is a necessary part of the Hamiltonian approach because the Hamiltonian approach, because the Constitution doesn't actually state the objects of government except in very broad terms of the preamble. But I don't think Hamilton or anybody for that matter was looking at the preamble as, justiciable, authoritative in the way. Yeah. So the powers do play a role, no question. But I think not. I guess I would still disagree with Professor Werman what kind of role they play.
Okay, I will, with the very fine questions we have in the queue, I'll stay sort of with the spirit of your argument and stay broad and general. But we do have some questions that move to the more some more specific questions. But I'll
try to be specific, but there's some things I'm more prepared on than others.
I'll move in that direction, stay general, and then move to the specific. So this is from Beckett Rueda. This is a beautiful construction that Professor Zuckert has laid out. Madison's position seems to lend itself in principle to a far more confined and static constitutional structure, which in part is the set of questions you raised at the end. So here is Beckett's question. Broadly speaking, what is the origin of this design or this conception of constitutionalism? Who were Madison's influences? In particular, could Professor Zuckert please comment on its possible relation to natural right as understood in Grotius or Locke or Montesquieu Rousseau, or natural law in Aquinas? To any of these, why take this approach as the properly constitutionalist approach to a written document and then its construction?
Well, this is a good question, very good question, a very broad question, as you suggest. It seems to me that the answer to the question is, in a way, none of the above. That is, Madison was heavily influenced, if you read other things of his, by at least two of the writers that the questioner asked about, one of them being Locke, the other one being Montesquieu. That these are two thinkers whose thought one can find the footprints of all over Madison's writings, or his speeches for that matter. However, none of those writers actually were dealing with the exact situation Madison was dealing with, and that is the fact of a written constitution. That is, Locke does not talk about a written constitution, Montesquieu does not talk about a written constitution, and the most important aspect, maybe the most important aspect anyway, of what Madison is getting at here is related to the writtenness of the Constitution. And this was a theme that developed partly in American thinking, that is, the American experience was of written constitutions for a variety of different reasons. And that one of the things that the Americans, and in this I think Madison shared a view common to himself and many others at the time, one of the points of writtenness was as a way of confining constitutional powers so as to make them safe and secure for the people. And so it's that aspect which does not play a very well, no role to speak of in the prior thinkers that the questioner asked about. So while there are tracks certainly of Locke, Montesquieu, perhaps of Thomas Aquinas for all I know, but in Madison's thinking, nonetheless, it's this business about a written constitution and what a written constitution can do for you that gives you very precise guidance as to the powers that you're talking about, for example, as in this case. So that's I think the best way to deal with that question. Yeah.
Okay, we have a question I believe is from Bill Allen at
Bill Allen, all right.
Well, it's from CU Boulder, and I'm thinking by the phrasing of it, maybe William Allen, a distinguished visiting professor at CU Boulder this year. And it is great talk, Michael, nuanced, careful, provocative. My question is, in terms of James Madison rejecting the notion that legitimate ends could constitutionally justify the means, how do you think Madison would respond to the issue of emergency war powers? So would Hamilton have thought Madison was not only wrong, but naive about the realpolitik nature of international affairs? And if Madison took a similarly sort of restrictive view about emergency war powers, could he have been judged as naive about the realities of the world?
Well, the simpler question, would Hamilton have considered Madison naive? I think the answer is probably yes, maybe almost certainly he would have. I think Madison, on the issue of emergency war powers, stood partly with Hamilton, that is in favor most of the time of a broad reading of congressional powers, of federal power to deal with crisis situations of one sort or another. But as I think he differed from Hamilton in that he saw Congress as being the more as the part of the government which had been entrusted with the powers to deal with those kind of issues more than, or at least on a par with, the executive. So he's a more legislative centered emergency guy. So he didn't accept, I think he agreed with Hamilton about one thing, which is that the Constitution should be written in such a way that all the powers that you need are going to be in it, and that you don't have to just go outside of it in order to deal with emergency situations. I think Madison saw things that way. And so the example he gave about the treaty power, which I think could have been what prompted this question by Bill Allen, I think Madison would say there aren't any gaps in the Constitution of that sort, even if we'd have to respect that gap if it were there. I think he thought the Constitution was written in such a way that it did contain the powers that were needed. And I think he differed from Hamilton again as is indicated in the Helvidius Pacificus debate that they had, that Madison sees the legislature as the body which has the most authority in these matters. The executive is not as prominent as in the Hamiltonian or Trumpian version, for that matter. I think Madison was not a Trumpian.
Our indispensable and excellent staff, who normally keeps me in line but can't always, have just clarified for me that CU Boulder is Colleen Sheehan.
Oh yeah.
Also
okay.
visiting.
I'm not surprised.
But
all right.
For reasons that will become clear later, I'm associating her with not with CU Boulder at the moment. And now a category of questions. Generally, I'll put it under the banner of 1816 and Madison as president. So we have several questions in this category. You refer to this in the draft paper that you sent around to us at the beginning, that you're not going to address that, but You'll have to trust me that these aren't coming from me, Michael. These are from people in the queue.
I trust you.
I'll name some of them.
Okay.
So Jacob Foberl asks, although Madison's argument seems to suggest the national bank would be unconstitutional, my understanding is that he later comes to accept the creation of a bank when he is president. Why? Yeah. And what lessons should we draw from Madison's behavior vis-a-vis the bank as president? Now, if you'll wait for me for just a moment, I have two other versions of the question just to get them out and see if there are any differences.
Okay.
The next one is from Adam Seagrave.
Okay.
Is Madison's later shift on the constitution of the bank a rethinking of any of this original position from 1791? Is it new thinking? Is it different thinking? And then one more.
Yeah, okay.
This from Colleen Sheehan, we now know.
She already asked her question.
Well,
We'll give her another one, yeah.
It could be Elon Werman writing in as a third, I'm not sure.
Yeah, okay.
In the same vein, right? This is sort of the 1816, 1817 Madison. Because you cited Lance, it makes me think of this question. Consistency, inconsistency. She phrases it as Madison admits to a change of position on the national bank in 1817. He gives an explanation for this. How does your interpretation of the 1791 stance relate to or square with Madison's later reasoning? So similar versions of the same question. Floor is yours.
Yeah, okay, this is good. And Madison, of course, was confronted with this question at the time. And he gave answers which are perhaps not entirely satisfactory. And so to the one question, does what he did in later when he was president and signed the bill for the bank, does that indicate a shift in his thinking? Well, let me say, I think it does not indicate a shift in his thinking about the necessary and proper clause, or a shift in his thinking about the general approach to constitutional interpretation. So at that very broad level, I don't think it represents a shift. I think if we asked him what the necessary and proper clause means, he would have given pretty much the same answer. So Madison gave he gave at least two kinds of interpretations of what might justify him signing the bank bill the second time around when he opposed it earlier. One was something like this. It wasn't quite as I'm putting it maybe more formally than he would have or than he did, but that he recited the history of the bank bill, or the bank in America, how it had been accepted, and then it had been let lapse, and then it was reaccepted, and that there were congressional elections that occurred between various of these actions, and that this indicated a kind of acceptance of the constitutionality of the bank by the people, by the nation as a whole. And it's almost as though he had a kind of theory of tacit constitutional amendment. That is, that whatever may have been the status of the bank before, there had been some kind of change in the way we understood the Constitution, and that therefore now the bank was justified by that for that reason. Not entirely satisfactory explanation, I think. The other explanation that he gave was, it's a little, I'm having a hard time kind of recapturing it now. Yeah, I'm sorry. I've just lost it. I had it about 10 minutes ago.
Isn't one of the arguments that, if not Madison, others make, is that the coining, you could reinterpret, there's a different argument that Hamilton and even Washington did not make in the 1790s, that they made in 1816, which is to emphasize the coining, the clause in Article 1, Section 8 about coining. Isn't that one of the different arguments? So that would be it's a consistency in Madison's view. The advocates in the 1790s did not make the proper kind of connection to enumerated powers in Article 1, Section 8. But here's a new argument that was not made at the time that we now, based on constitutional experience, national experience, can say is the appropriate anchor.
Yeah. Again, I think I had in mind something like that, that he was reinterpreting the connection to enumerated powers. I guess from the point of view of what I'm trying to do in this paper, all of that is sort of irrelevant. I mean, because the issue of the bank itself is not really the question. Is the bank constitutional? That wasn't, from my point of view, the interesting issue. The interesting issue is how should we read the necessary and proper clause? Yeah, I'll just leave it at that. I mean, I think it would be perfectly compatible with his earlier position if he were to come to a reinterpretation along the lines you suggest of how the bank in fact relates to certain of the enumerated powers. And I think that is one of the things he said, but I'm just not. You might be right. It was coining. I just don't remember what it was. For that part, I'm a long ways away from his later opinion about it.
It was for those of us not as fluent in history in relation to constitutional development, so to speak. It was a jarring experience to have the nation's capital invaded and burned. In the aftermath of that, there's different context for constitutional construction and constitutional interpretation about Article 1, Section 8. Okay, so moving on to, again, staying at this broad level, and then Sean Beinberg, if you would be very patient, I will get to your more specific historical question, because we still do have time for that. So here's a question from Matt Van Hook.
Okay.
Should those enumerated powers that point to major objects of government, such as military and defense powers, have a higher stature than those enumerated powers, for example, postal powers? Question. And then his final sentence, it seems that this is Hamilton's position, but is it possibly Madison's position as well? I guess to interpret it, you could reasonably make a ranking of the importance of the enumerated powers and those which might need implied powers more because they are more substantive. That might not be a fair rephrasing of Madison. I take it.
Yeah, I mean, I'm sure Madison saw that some of the powers were sort of more central to what governments had to do than others of them, and so he would accept, I think, that part of the premise of Matt's argument. I'm just not sure that anything of substance would follow, however, from him doing that. I think he would treat the basic question, is this a necessary and proper means to the effectuation of enumerated power? That would still remain the question, and that if something were related to a big power like that, it would still have to answer that same question. I just don't see how, in Madison's way of dealing with it, it would make any difference.
Could I add a footnote follow-up question? And I'm looking here at page 11 of the draft that you gave us, and you did read this part, quoting Hamilton's emphasis on acknowledged objects, right? Objects of lawful ends of the government. And then you have the statement that Madison says this is not what the necessary and proper clause authorizes. It authorizes a focus on enumerated powers. And then you have this sentence, perhaps the Constitution would be a more rational document if it were as Hamilton construed it to be. So here, a reply question. Isn't there a way of understanding Hamilton's opinion from the 1790s, the court in McCulloch, and a reasonable mode of constitutional construction as saying that the issue is the direct versus indirect appeal to these legitimate ends or objects of government. Because at one point you use the phrasing, Madison's objecting to a direct appeal to legitimate objects or ends of government. So my question is, wouldn't any reasonable, or isn't it a reasonable mode of construction of the Constitution to look at the enumerated powers and then need to say, what do these mean? They would have to be construed, understood, interpreted in light of the objects or ends of the government as a whole, taken from the preamble, taken from other knowledge about purposes of the Constitution. So is it the direct appeal to objects that you interpret or Madison interprets as skipping the enumerated powers? That's the infraction, whereas an indirect interpretation as a way, an indirect appeal, I'm sorry, to objects, legitimate powers, as a way of interpreting the particular language of the enumerated powers, that would fit better with Madison's view.
Well, I don't see Madison making a move like that. I mean, that whatever that might signify, and I'm inclined to the view that Madison would resist that. I mean, let me take the example that I put into the paper of torture. So I'm not saying Hamilton would have made this very decision, but let's say it's thinkable that the question comes up, may the government use torture? And it's not among the enumerated powers for sure. One could argue along Hamiltonian principles that, well, we see a lot of powers that are devoted to national defense, and torture could be an instrument of national defense, and therefore national defense as an object, and torture is a means towards achieving that object, and therefore torture would be could be interpreted as necessary, proper power, although whether it's proper would be, of course, an issue, but it could be interpreted as a necessary power to effectuate the object of national defense. It's not clear to me that it could be interpreted as an object, as a necessary and proper power related to any of the enumerated powers, however. So I think there are certainly cases where there's going to be a difference in how one comes out on this. I mean, maybe you could give a counter example of how you think it might, the indirect appeal to objects could produce the same kind of result.
It turns out that brilliant minds think alike, and Peter McNamara posed a question very similar to mine. But I'll read it, and it really comes in two parts.
Yeah.
So, and he says, by the way, this is Peter McNamara, not Elon Werman, posing as Peter McNamara. Don't you have to understand the enumerated powers in light of the great objects of government, both those stated in the preamble and enumerated powers understood commonsensically? So, and then he continues. For example, I think he's giving here non-commonsensical ways of interpreting. Someone might think of raising a navy in terms of regulating what a yacht club does, or they might think of raising an army in terms of Bastille Day parades, a la President Trump. So interpreting the preamble and the enumerated powers commonsensically would involve appealing to larger objects of government. And then he has a sort of a footnote. Hamilton does say in the Bank opinion that the police power is a state power, not a federal power. And so that would make, how to put it, Trump is not a Hamiltonian if Trump, that the president has absolute authority for public health. So that's Peter's question.
Yeah. Okay, so Madison clearly believes that the powers are meant to be and should be interpreted in the light of the objects. Yes, I would say that's clear. If you read the Federalist Papers 41 through 46, where Madison goes through the list of enumerated powers, but he organizes them in terms of their objects, and he interprets them in the light of the way they serve those objects. Absolutely. But nonetheless, he I think would say we interpret the enumerated powers in the light of the objects, but we do not infer powers direct from the objects that are not incorporated in an enumerated power. That's, I think, that would be the difference maybe between where Peter's going on that and where Madison was going.
Okay, we have, I'm allowing one follow-up question, and then poor Sean Beinberg, I will get to his question. So Zach German has one follow-up, then we'll have Sean Beinberg's more historical question, and then I might have time for one last sort of summative question to you. Okay. So Zach German asks, what does, in a Madisonian interpretation, what does the word proper do in the necessary and proper clause? Does it simply mean that laws must not violate a clear, specific constitutional provision, or is proper meant to be understood in a more expansive sense than that? Does Madison have a particular opinion on the word proper and its function?
Good question. I think I have to say, so to my knowledge, Madison never said anything about that. And so I don't have an answer for that. I just don't know. He never seemed to give weight to the proper part of the necessary and proper clause. So yeah, I just don't know. I should say I don't know. Sorry,
okay.
Zach.
Okay, and then Sean Beinberg, very patiently, he was the first question to pose in the queue.
Okay.
But I just thought in terms of our discussion, this might be best brought up later. So his opening way of posing this question is, does Madison win, and I'll add my interpretation, Madison win in some larger sense of our constitutional history and interpretations? For example, which later major political coalitions, if any, do you think pick up this Madisonian view of the necessary and proper clause versus the Hamilton-Marshall understanding? And then he gives some further examples. That is, do you think, for example, Henry Clay and the National Republicans and the Whigs, or Republicans understood in Lincoln's sense, or FDR and the New Deal have any connection to the Madisonian understanding of enumerated powers? Or do they really focus more, does everybody focus later on the Hamilton-Marshall, at least rhetorical emphasis on objects and ends of government?
Okay, so it seems to me that that's good, it's an interesting question to sort of look at the whole scope of American constitutional history with this kind of question in mind. It seems to me that since the New Deal, the Hamiltonian approach has certainly dominated, and that one can't make a case that Madison has won out there. In fact, I'd say the court has, for the most part, been pretty explicit in rejecting Madisonian constitutional moves in the New Deal, post-New Deal era. So there. Now, the Henry Clay, so one of the things that happened, 1800, the Jeffersonians win the presidency, and they have a big impact on the whole government, obviously, from then until certainly till 1860, including the Whigs. And while I don't see evidence, I mean, maybe it's there that I just don't know about it, I don't see evidence that the Madisonian theory of the necessary and proper clause is actually picked up by anybody in particular. But there is a more, for the most part, more restrained, certainly in the era of the Democrats controlling Congress, of a more restrained kind of government, and you might say a more, that's somewhat Madisonian, maybe more Jeffersonian, but it's nonetheless on the side, on the anti-Hamiltonian side of things. With Clay, I see the Whigs as sort of in between the Jeffersonians and the Hamiltonians. They certainly don't go as far. They're more legislative oriented and so on. They certainly are more on some of the issues where Madison had serious reservations, like internal improvements. the Whigs are certainly maybe more Hamiltonian, you could even say, that is, they are more supportive of the internal improvements. Lincoln wrote a constitutional opinion supporting internal improvements as a Whig, a former Whig anyway. So I would say there's no evidence that Madisonianism on this issue per se ever dominated, but that positions more like Madison had a stronger role in the 19th century than they've had certainly since the New Deal.
Would one instance of that be Jackson's decision that, regardless of what everybody else had done, including Madison and Jefferson, because Jefferson did write publicly in 1816 that he now accepted the Constitution out of the bag. So what Congresses, presidents, including Jefferson and Madison, the court had ruled, Jackson now says, no, this bank is not constitutional. Does he, I can't remember the details. Does he appeal to Madison of 1791, or just say, I am Andrew Jackson and I say the following?
He issued a formal opinion about it. Yeah, again, I don't know the details. You guys are all pressing me on the bank, which is not what I was focused on. So I just don't recall what exactly Jackson's constitutional case was.
Let me finish with two broader questions, which in some ways point to one of your opening remarks, the relevance and
You're muted, Paul.
I'm sorry, I was trying to manipulate something. The question came from Kevin Vance, and then it just someone removed it. So one of the elves has gone rogue and removed the question. So let me try and remember it and rephrase it. Okay. Would we do better in the 21st century to restore precisely this Madisonian view of focus on a careful construction of enumerated powers and reasonable arguments about whether some means to effectuating those are necessary and proper? Wouldn't it bring some salutary, here I might be putting words in his mouth, wouldn't it bring some salutary discipline to lawyers and judges, to political arguments, to confine and sort of discipline the scope of argument? I think that's what he might be getting at. Would that be salutary for our legal constitutional culture, for our political constitutional culture?
My general inclination is yes, and that is definitely in that direction. It's a big question, though. I mean, the country, in some ways, the Constitution have evolved in ways that isn't clear that Madison's original understanding is what we need. But it's my inclination to say, yeah, I think we should give it a try anyway, and that it would have some of the good effects that you mentioned. Among other things, it would give a little more heft to the meaning of federalism. That is, we'd be able to draw lines a little more clearly between the federal government and the state governments, and I think the federalism would have a firmer footing than it does right now. So I would generally, if that was Kevin was pointing that direction, I would endorse that.
Okay. In fact, the elves actually restored the question to me. Kevin, I'll ask if you would send by email to Michael Zuckert your question. You could, because it is slightly different, but there's overlap. I didn't completely imagine a different question, but there are some specific points he should bring up with you. So final question for me. Your last point. It could be said that one of the amazing powers of President Trump is that people who for many decades have not been friends of the original constitutional structure and its principles, whether you want to call it the Madisonian Constitution, the Hamiltonian Washington Constitution, ideas like federalism, a real and serious distribution of powers such that there are real sovereign powers in the states, let's say, substantive powers in the states, and then real powers in the national government, or that the presidency is not the be-all and end-all of the constitutional order. These quaint old principles suddenly find new advocates, new friends in the Trump era. But to be a little less polemical, isn't it?
Was that polemical? Sounded like pure moderation. What are you talking about?
Isn't it extraordinary that here we are, 230 years after Madison first made these arguments, in 230 years of a breathtaking change in politics and society and technology and life, partly because of the American constitutional order and what it has brought about. Isn't it somewhat humbling that these ideas just won't go away? That these debates and these ideas, we for various reasons, high-minded, maybe some low-minded and the polemical of the moment, we keep reverting to these principles, and then we look to sources and say, well, what was initially said and what was the debate at the time? Isn't that a hopeful sign in a way about the idea of a constitutional order? Isn't it hopeful about, we can be so polemical and narrow-minded, but we still have plenty of people who want to look to a broader, deeper set of resources.
Mm-hmm. From your lips to God's ears.
So I suppose that part of the argument is how we try to turn. I'm seeing the somewhat ungenerous phrase that there are fair weather friends of federalism or fair weather friends of proper presidential power, meaning not unlimited presidential power, but properly constrained constitutional power. There are fair weather friends. We want to make them not just fair weather friends, but all weather friends.
Right. No, I think that's a good point. It really bears on your original statement there, which is, yes, there's a kind of recurrence to the Constitution here, but one of the things, that's good. I'm a big fan of the Constitution. I'm a big fan of Madison. So I think all of that, those are good moves. But on the other hand, they're so inspired by a partisan, polemical approach, and so I think it does breed fair weatherness. That's one of the problems, that we need an attachment, an appreciation, maybe an appreciation first, and then an attachment once we know what we're appreciating to the Constitution itself, and not just when it happens to fit our partisan perspective of the moment. That's what I think is less than wonderful about the present turn back to the Constitution, which is an important step towards maybe getting to where we'd like to be. But this is a task for SCETL. You're muted, Paul. There you go.
I think Joe permanently muted me. Someone ought to invent a separate department to focus on these questions. That's a good idea.
Somebody ought to.
Yes.
Yeah.
And with that, we've come to the limit of our time. Thank you very much, Michael, Professor Zuckert, for great presentation and for responses to all these very interesting questions. Thanks to everybody who attended and especially those who did pose these excellent questions. Of course, I have to say in closing, like any such event, it would not be possible for Michael and myself and others to enjoy this conversation were it not for the hard work of the staff of the school. So special thanks to Carol McNamara, who is our Associate Director for Public Programs, Joe Martin, our Communications Manager, Claire Turpak, Morgan Raddick, JC West, others who helped to make this possible. For our friends far and wide, please take note of our recently invented and entirely fascinating public programming online, the Pandemic Dialogues, which feature live webinars, which are then recorded and available on our website, and a podcast, which focuses on Camus' 20th century novel, The Plague. Look for information for those on our website. And with that, again, thank you, Michael Zuckert.
Thank you.
Thanks everyone for joining us. Be well and good night.
Good night.